This application is taken the order of punishment. Punishment.
What punishment?
Reduction in rank and
Reduction in rank. From what post to what post?
From senior administrative grade to senior administrative grade to junior administrative grade in the bank.
Senior
Administrative grade. Annexure 1 is the improved order, my lord. At page 44, your lordship will.
Senior to junior.
Yes.
Junior or administrative grade?
Administrative grade. Your lordship will kindly see.
You are promoted to the post of senior administrative grade?
Yes. When the case was pending, the petitioner died. He was substituted. Then I will request your lordship to kindly have a look at the order dated 26/6/2015. Order number 9. This court has taken note that now since the petition.
Order number?
Yes, my lord. Dated 26/6/2015. The first page is irrelevant. In this case,
The legal ground is there?
Yes, my lord.
If I interfere, otherwise I will not.
yes, your lordship will find that in this case, the only ground which I have taken, that right from the very beginning, my lord, I was making an application before the authorities that the inquiry officer should be changed. That is changed because he was prejudiced. My lord, that
What is the date of appointment of inquiring officer?
inquiry officer slipped to I'm just giving to your lordships. In fact, my lord, annexure 3 is the charge sheet. Annexure 5 is the.
All right, sir, please answer. What is the date of appointment of inquiring officer?
Inquiry officers, the report is dated 22/1/2007, but charge sheet was dated 5/4/2006. That is not annexure 3.
Please answer to the court question. If you don't have answer, please say, I don't have. Don't circumvent the court
The
question.
date of the inquiry officer's appointment has not been.
Sir, we want to know what is the date of appointment of inquiring officer? Because you have raised the issue that he is biased against you.
Yes. That your lordship will find from annexure 5 itself.
Please don't ask me to find out. Find out what is the date.
This is dated 14th of September 2006.
14th of September?
2006, the application was filed. And
No, the date of appointment of inquiring officer. This is third time I am repeating.
Lord, I have got it, Lord.
Yeah.
The charge memo is. The thing is that since he is dead. Charge memo, Lord, is at page 45.
What is the court is asking you?
The irregular allotment of funds.
No, what is the court is asking you?
The court is asking.
Provide the
date of appointment of the inquiry.
Say I have or not.
I have got.
Say,
Yes.
Be frank.
Yes.
Then we will examine.
Yes.
Where is the order of appointment?
My lord, page 13 of the counter update notification dated 22/2006. 22nd of August 2006.
Appointment of inquiring officer.
My lord.
For the first time, petitioner has raised the bias against inquiring officer on what date?
Yes, that is I am giving you lordships. Annexure 5 that is dated 14/9/2006.
14?
9/2006.
Where is the document?
Annexure 5, my lord. And this issue was also raised before the appellate authority by annexure 9.
All right, sir, I will get up and go. If you are jumping the facts of the case.
Annexure 5 at page 61.
You are a designated counsel, senior counsel. Who is your, whether disciplinary authority has taken any action on this?
No,
No.
no finding on this. No action was also taken. And this was, my lord,
What is the bias against him, the inquiring of the authority?
I was directly working under him and he had a bias because I was under him in the bank. In the
So
same,
we are working directly under him, does not amount to bias.
the bias, my lord,
Was there any confrontation, some incident between?
my lord, that there was, but the only thing is, my lord, that I am handicapped with the fact that since the petition is dead, that I cannot take any instruction as to what had happened.
But you are not in disclosure, you means petitioner has not disclosed in another file. To what extent?
But that is the first time the application was made. And the same thing was, my lord, taken at the election 9 itself in the appellate.
Was one incident that the petitioner has, petitioner.
My lord, this I cannot show, my lord, to the lordships because I have said that since he is dead, my lord, I could become your lordship
Alright, that's all.
another time.
Alright, that's all. Take up. In the instant petition, petitioner has prayed for the following relief. The petitioner, while working as a senior manager,
No, he was only
Suppose-
manager, he was only
the
manager.
manager, Sabor branch, STABOUR. He was subjected to disciplinary proceedings in framing article of charges on 5/4/2006. Petitioner had submitted his explanation on 24/4/2006, relaying the alleged charge. First of during the pendency of the inquiry, he had submitted for change of inquiring officer on the score that inquiring officer is biased against petitioner. Such a request was made to the disciplinary authority on 14/9/2006. No doubt, disciplinary authority has not passed any order either accepting or rejecting. At the same time, before conclusion of the departmental inquiry on 22/1/2007 in submitting the inquiring officer's report, the petitioner should have invoked remedy before this court so far as change of inquiring officer. Further, it is noticed that request for change of inquiry on 14/9/2006 is not substantiated by any event like scuffle, like oral altercation or any incident among the petitioner and among the deceased petitioner and the inquiring officer. Who is clearly alleging bias in the absence of any event, one cannot draw inference that inquiring officer was biased against the deceased petitioner. Full stop. Thereafter, the inquiring officer submitted his report on 22/1/2007. The result, a second show cause notice was issued and the disciplinary authority proceeded to impose the penalty of reduction in rank from the post of a senior administrative grade, administrative officer grade to that of administrative officer, who is feeling regret and dissatisfied with order of penalty. The deceased petitioner prepared appeal on 23/7/2007 and it was rejected on 8/8/2008. Hence the present petition. Then senior counsel Mr. Swain restricted his argument only to the extent that deceased petitioner has raised bias against the inquiring officer No other
Just a minute.
allegation has been raised other than biased ground. It is necessary to reproduce the Annexure 5 dated 14/9/2006 insofar as raising the issue of bias against the inquiring officer. So perusal of the letter dated 14/9/2006 of the petitioner, deceased petitioner, it is evident that very vaguely contention has been taken that the inquiring officer is biased. In other words, in the absence of any alleged incident among the deceased petitioner and the inquiring officer, one cannot draw inference that the inquiring officer is likely to be biased against the deceased petitioner on the sole ground that deceased petitioner was working under the inquiring officer. During pendency of the present petition, the petitioner has died and LRs have been brought on record. Next, in the light of these facts and circumstances, question of interference or a judicial review in a disciplinary proceedings is not warranted in the light of appeals court decision in the case of State of Karnataka versus Umesh, reported in 2023, so and so. Accordingly, writ petitions stand dismissed.
But being a lordship's request for one thing, that in the memo of appeal also he has taken this specific point, and the honorable single bench by order dated, and so order number 9, his lordship has said that they have to produce the record because their lordship was wanted to see.
That is not binding on me at the time of taking final.
That I am just bringing to your lordship's notice the order below the import, why the honorable judge below says that the record should be produced. Because whether what the question your lordship is putting below, it is very difficult for me to say at this stage what has transpired. His lordships wanted to know whether there was any such incidents or report to the inquiry officer or to the disciplinary authority. So therefore, I wanted.
No action has been taken on your representation.
Yes.
You had a cause of action to approach this court.
Yes, your lordship is correct, but I had taken the approach before the appellate authority. The appellate authority also did not pay any attention to it. So therefore, I had come to your lordships.
Sorry.